We recently resolved a case with the insurance companies for off-track betting as well as for an individual who had frequented off-track betting. My client is an elderly man who would go to OTB on a fairly regular basis. And while he was there one day, an individual came up to him and told him that he was sitting in his seat. And when my client stood up and said, the seats don't have names on them, this individual decided to push him and he fell to the ground and he injured himself. We brought litigation, sued the case in the New York State Supreme Court against the individual who pushed my client as well as OTB. The claim against OTB was that they knew again or should have known of a dangerous propensity of this individual because he had been loud and boisterous before, and that they should have had some type of security inside of OTB to protect people from known dangers. Obviously, we also sued the individual who pushed my client. Now, in these cases, there's a concern because most homeowners insurance policies have an exclusionary clause for intentional acts. That essentially means that if you intentionally harm somebody, your insurance company no longer has any responsibility. Now, in this case, we not only argued that the act was intentional, but we also argued that the act was an unintentional consequence of an intentional act. And after putting the case into suit, we were able to successfully settle the case for 6 figures, with contributions not only from the individual who pushed my client, but from contributions from off-track betting as well.